where the court might be headed in the terms to come. So no shortage of good material, and we're excited to share it with you.
Yeah, absolutely, absolutely. So I guess where we wanted to get started is just take a kind of a high-level overview of where the court stands now in terms of its personnel and the coalitions that could be forming on the court. I think everyone knows that the court is generally seen as a 6-3 court. There's 6 justices that are appointed by Republicans, 3 appointed by Democrats, and you will see, at least in some of the cases that we discussed, you do get that 6-3 lineup. But other times the lineups are more interesting and heterodox. And the kind of the most common way people describe it is it's either a 3-3 court or a 4-2-3 court, with Justice Gorsuch and Justice Alito and Justice Thomas kind of on the right flank, the Democratic appointed justices on the left flank, the Chief Justice in the middle, and then people have different views of where Justice Kavanaugh and where Justice Barrett are, and it varies by the case. And sometimes you'll have just wild lineups that are reflected necessarily in any of those kinds of simple perspectives. But
yeah, I mean, I guess the one thing I always feel like when my liberal friends complain about, the conservative Supreme Court and this, right-wing conservative block of 6 justices, I'm always like, oh, would it were only so, would it were only so. But no, I mean, the notion of a unitary conservative block in the Supreme Court, I think, has been exploded. Certainly we saw last term, I think we're going to see this term, that the idea that all 6 quote-unquote conservative justices march in this, lockstep without breaking rank, I think is just a myth, and I think we're going to see that play out over the course of this term. I guess one just final observation before we start kind of talking about some of the cases is, for me at least, one of the interesting changes in the dynamics of the court was after MISHA's former boss, Justice Kennedy, retired. As you all know, Justice Kennedy for many years was kind of, the quote-unquote swing vote on the court, right? If you had a hotly contested case where you needed a 5th vote, particularly one of those like supercharged constitutional cases, you needed to get that 5th vote, you needed to play for Justice Kennedy's vote. He was the median of the court, and people would angle for his vote. One of my favorite anecdotes is advocates before the Supreme Court would literally have amicus briefs authored that all they would do is cite Kennedy opinions. It would be like the law according to Justice Kennedy. Like, Kennedy concurring, Kennedy dissenting, Kennedy majority opinions, because they understood the importance of obtaining and securing that 5th vote. Now, of course, when Kennedy left, of course, everyone's like, well, who's going to be the new Justice Kennedy? And I think that the betting money was on the chief, that Chief Justice Roberts would become kind of the new swing vote. And, if the liberals thought they could peel off a conservative, they would go for Roberts. What's really been interesting is that in the last term or two, particularly last term, the justice who was in the majority more often than any of his or her colleagues, 97% of the time in the majority, was Justice Brett Kavanaugh. 97% of the time. Which was Kennedy-esque numbers. I mean, in Kennedy's big years, when he was in the majority most often, that was the number. It was about 97% of the time. So if you want to, kind of impress your friends with, parlor tricks at cocktail parties about predicting outcomes of Supreme Court decisions, figure out where Brett Kavanaugh is going to be on a case. You're going to be right 97% of the time.
Right. So but as Tom said, that those kinds of lineups, that we're talking about here are not always the case. And the first case we're going to briefly talk about from last term shows that. And this is the big Obamacare case. And that ended up, that was a challenge to the Affordable Care Act. In the 2012 decision, the Chief Justice famously said, well, Obamacare is most likely read as a mandate and then a penalty, but I'm going to creatively read it as a tax. So then, fast forward a couple of years, the tax is repealed. So the state of Texas says, well, aha, the tax is gone. Now we're back to the thing that the Chief Justice said it was most likely, which is a standalone mandate. And didn't you say, Chief Justice, this was unconstitutional? So this case went up through the lower courts. The Fifth Circuit said, yeah, that logic kind of works. And then it went to the U.S. Supreme Court. And the U.S. Supreme Court, in a 6-3 decision written by Justice Breyer, well, it was, and then Justice Thomas did a solo concurrence, said that the plaintiffs had no standing because nobody was able to enforce, that the defendants, which is the United States in that case, were not able to enforce the ACA because they had no power to enforce it because the penalty provision was zeroed out. And so everyone had a great lot of fun at Texas's expense, saying, "Oh look, you lost this case." Everyone said we were going to lose it. And then if you if you look at the very famous recent order at the U.S. Supreme Court, why they didn't enjoin the abortion case from Texas. One of the things the Supreme Court, I believe, cited in that order was the ACA case saying, well, you're suing the state of Texas. The state of Texas can't enforce this law. Just like the ACA, there potentially is no standing for you to sue the state of Texas over a law the state of Texas doesn't enforce. So, Texas had egg on its face in the ACA case, but then it came back around in its favor with regard to the abortion law.
So when's the next Obamacare challenge coming up?
Seems
like every year it's like.
Look, politically, I don't know if it will occur, but for all the kind of crowing by those who are opposed to the lawsuit, the Supreme Court really decided the most difficult standing question on an argument of waiver, which is that nobody had standing to challenge the mandate because it couldn't be enforced. But there was an argument that Justice Alito accepted in dissent that if you have provisions that are inseparable from something that can't be enforced against you, that is being enforced against you, then you have standing. And Justice Breyer brushed us off saying, well, Texas didn't make that, and that argument is waived. And that argument, that finds its way into a lot of cases. So theoretically, somebody could bring back the ACA, the same exact ACA challenge, actually make that argument, and then the Supreme Court would have to actually address this issue again, and I'm sure they'd find a fourth creative way to uphold the ACA.
I will not quarrel with that prediction. So that's actually a good segue to my favorite case of the last term, our discussion of standing. My favorite case was TransUnion versus Ramirez. Now, as someone who's kind of like an Article 3 hawk, this case has everything you could ever want and more. This case involves a situation where one Mr. Ramirez goes to buy a car at a car dealership, accompanied by his wife and his father-in-law. And so he's in the negotiations, and I envision, like, for those of you who've bought cars, you know the experience, right? You're like sitting in a little room, the salesman's like, well, let me go talk to my manager and I'll see what we can do for you, right? It's like the guy goes away, comes back 5 minutes later, and he tells poor Mr. Ramirez, no deal. Why? Well, they ran a credit check on him, and apparently, allegedly, Mr. Ramirez's name showed up as like on the terrorist watch list. Okay, like no joke, right? It's like happens to all of us. You go to buy a used car, you're told you're a terrorist, no can do. Well, it turns out that he was not in fact a terrorist. At least according to the allegations from his subsequently filed complaint against TransUnion, he was not a terrorist, and TransUnion, which did the credit check, just screwed up. They didn't, run the right search, or they didn't, cull the data in the right way. But anyways, that was the problem. He wasn't a terrorist, but he was wrongfully denied his car loan. So, like any good American, he sues. And basically, the argument here is, does an individual suffer a cognizable harm sufficient to satisfy Article 3's case and controversy requirements by this sort of, I guess for lack of a better word, regulatory mishap? There wasn't any dispute that, according to the allegations of the complaint, TransUnion violated the federal statute, FCRA, when they failed to, do the right stuff on his credit check. But the question that ultimately percolated up to the Supreme Court was, did he actually suffer a cognizable Article 3 injury, entitling him to sue in federal court? Not just for himself, but for the 6,000 other people who had been similarly allegedly victimized by TransUnion. So what was interesting about the case was the Supreme Court actually said the answer depends. They said that Mr. Ramirez did have standing to sue because he had suffered a quote-unquote concrete harm. In other words, TransUnion's screw-up had resulted in a tangible harm. He was denied his car loan, he was injured. However, thousands of other individuals on whose behalf he had sued in this lawsuit who didn't have a similar experience. They didn't go into a car dealership and were denied credit or anything like that. The only alleged injury those people had suffered was simply their name was in TransUnion's internal files. I guess it's like a potential terrorist. And the Supreme Court said that's not good enough. There was no external harm, there was no concrete injury. And so that, according to the Supreme Court, is the dividing line for when you can sue in federal court and when you can't. If you have suffered concrete harm, yes, the courthouse is open. If you have not suffered concrete harm, closed. What was interesting about this, going to our introductory point, is the alignment. This is a 5-4 decision. The 4 dissenters who said the courthouse door should remain open to all plaintiffs like this who have suffered a statutory violation, even absent concrete harm, mere violation of a statute. The 4 justices who said you can go in were Kagan, Sotomayor, Breyer, and that well-known liberal Clarence Thomas. Join those 4. So it's kind of interesting when people say, oh, conservative judges always vote alike. No, point them to TransUnion versus Ramirez.
And I would just say, all these other, TransUnion is probably the case that you were going to talk about today that you're least excited about. But for those of you who go,
Speak for yourself, man. I
No,
know.
for those of you who go into big corporate law like we are in, it is more important than all those other cases for our practice by an order of magnitude. All of them add together.
Well, and constitutional hawks, right? People who want to enforce the constitutional Article 3 case of controversy.
I mean, more-
we're excited about that too.
Very much, but I mean very practical. Is if you think about it, these companies, these credit reporting people, sometimes they'll mess up, like with regard to Mr. Ramirez, and they'll really harm someone. But most of the time, that can be a couple $1,000s or more, and the company will pay that. But the problem is that the plaintiff's lawyers, they bring in these big class actions. They find out what's an error that they find one plaintiff, like Mr. Ramirez, something bad happened to him, and they try to shoehorn all these other people that nothing really happened to them, and they try to recover statutory damages, statutorily defined amount, for a class of all of them, and you get tens of millions of dollars of lawsuits filed, these shakedown lawsuits filed by plaintiffs' lawyers. And Ramirez erects a powerful shield against those kind of, my obviously biased opinion, ridiculous lawsuits. And it means that those class action plaintiffs' lawyers got to find people who were actually harmed and recover for those, and not try to get a windfall because a same error might be replicated 10,000 times and only harm a couple hundred people. So, another case that got a lot of publicity last term was the big Voting Rights Act case from Arizona. And here Arizona had, I think, what most would describe as relatively banal regulations on voting. They said if you vote in the wrong precinct, your vote doesn't count. And they said that you can't harvest ballots, just collect absentee ballots for a bunch of folks. And this was challenged under Section 2 of the VRA because the plaintiff said, well, both of these methods are used by marginally more than by minorities than for other people, and therefore this violates Section 2 of the VRA. And those of us who work in the voting rights field found that kind of thing very common, which is that there'll be a voting regulation that seems like a relatively banal one, but there'll be a partisan interest because that voting regulation might end up reducing, or at least plaintiffs for one party might think, it's going to reduce the voter turnout for my side by 0.01%, elections can be close. So they will bring a lawsuit that says this violates Section 2 of the VRA because there happens to be a 1% difference between how much this group, minority group uses this particular ballot procedure versus somebody else. And this can be pretty frustrating as someone trying to defend these kind of laws, because sometimes you'll have a state that has very permissive voting laws. If you take a look at the entire voting system as a whole, it is very permissive as compared to sister states. And yet your state gets sued because they say, well, in this one respect, you've made it 1% less likely that folks will use this particular method. And what the U.S. Supreme Court here held in the kind of traditional 6-3 lineup, the one that, that the commentator, give one to the commentators on this one. Traditional 6-3 lineup is, no, they've really made it clear that you need a serious denial of the right to vote to prevail on a Section 2 claim. And while the Supreme Court didn't give any bright line rules, they did give several important considerations for those of us who work in the voting field are going to be quite important. They said the size of the burden is important. You don't just look at who happens to use it. Is it really burdensome, or is it kind of no different than the usual burdens of voting, showing up at a ballot box and casting your ballot? If it's no more burdensome than that, that's not a meaningful burden. They also said you have to look at the state system, voting system as a whole. So if your state's voting system gives people 20 ways to vote absentee, the fact that you take away one of those 20 ways can't make you illegal when your neighbor state only allows 10 ways. That doesn't make a whole lot of sense. Another one they said was that the baseline for whether you're making voting hard is what the right to vote looked like in 1982 when the relevant provision of the Voting Rights Act was enacted. And finally, they said that it is important to consider the state's interest, including the interest in preventing voter fraud. Now, a lot of plaintiffs in this area have tried to get almost every voting law thrown out based upon bringing in an expert that says, well, there's not that much voting fraud. And so what the Supreme Court said is the legislature is entitled to determine that voting fraud is a problem and that that is an important state interest, and that the strength of the experts that the parties happen to bring in can't displace that legal conclusion, assuming the legislature determined that that was the proper conclusion to reach in enacting the relevant law.
Yeah, these voting lawsuits don't seem to be going away anytime soon. I mean, if anything, it seems like they're just occurring with increasing frequency, increasing bitterness, with every election. I mean, you obviously lived it as the Solicitor General, but it just seems like this is kind of the trend of the future.
Yeah, and it's important, but I think it's important to distinguish the different kinds of voting lawsuits there are. What the lawsuit like this is, and like the lawsuits that happened in the summer, of 2020, some of the lawsuits that are happening now are really kind of the traditional type of VRA or First Amendment lawsuits to try to strike down voting laws. There was a slate of lawsuits that were of a different character that happened after the November election, and I feel like a lot of people have conflated those two lawsuits and have taken, which party brought which lawsuit and kind of try to bring them together. But this kind of lawsuit is very different in character from what was happening in those post-election lawsuits, and I don't think that they should be intermingled.
Yeah, no, fair point. And my practice tip to all of you: don't sue Dominion. Dominion did nothing wrong. All of these crazy lawsuits.
Dominion's doing a lot of the suing now themselves.
So okay, well, I'm not opining on those things as far as the voting fraud stuff. Anyways, let me talk about before we turn to this current term. Let me talk about one last case from the prior term, and this is a case which brings great pain to my heart because it's an area of the law that I know you also care about deeply, which is personal jurisdiction. The court had a case on its docket called Ford Motor Company versus Montana 8th District Judicial Court. That's just a kind of funky way that these types of appeals get styled. But this was the court's attempt to sort out the often confusing, complex world of specific personal jurisdiction. Some years ago, the court had a case called Daimler versus Baumann, which brought, I think, rationality to the world of general personal jurisdiction. Whereas before Daimler versus Baumann, you could sue companies anywhere in the United States, that did business nationwide. You could sue them in all 50 states. So like, Walmart, Amazon, Target, what have you, could be sued anywhere under the theory that they were doing business jurisdiction, gave you jurisdiction anywhere in the United States. After Daimler, it became 2 states that you could get general jurisdiction: the corporation's state of incorporation and its principal place of business, and that was it. So it transformed the law of general personal jurisdiction. And then when the court granted cert in the Ford Motor Company, I think a lot of us thought, this is great, they're gonna have kind of the equivalent of Daimler, but in the context of specific personal jurisdiction. Unfortunately, at least in my view, they broadened specific personal jurisdiction. They held in this case that Ford Motor Company could be sued in Montana in a personal injury case where you had a situation where a person had a car accident in Montana, it was a Montana resident, and they sued Ford for product liability, design defect, that sort of thing. And Ford's defense was, well, we can't be subject to jurisdiction in Montana because, yeah, even though we, Ford, do business in Montana, we have dealerships, we advertise, there was no suit-specific connection between our business activities and this lawsuit. In other words, this wasn't a situation where the plaintiff bought their Ford vehicle in Montana. The plaintiff didn't allege that the reason they bought this vehicle is because they were in Montana and they saw ads on Montana TV and they bought it. So in other words, the Montana connection, quote unquote, was not case specific. It just concerned Ford's general business activities. But to be fair, the business activities did concern this type of lawsuit. I mean, the guy was injured in a Ford vehicle. Ford sells vehicles in Montana, but there was just no personal connection. So the question was, is that sufficient for specific personal jurisdiction? Supreme Court said yes. Supreme Court said Ford can be subject to jurisdiction. They said that that connection doesn't need to be as specific and case-specific as Ford had articulated it, and that Ford's mere conduct of business, the fact that it sold its vehicles, it advertised its vehicles, was enough to subject Ford to personal jurisdiction in Montana in a product liability case. As I say, I wish the court had come out a little differently. I think a lot still remains to be played out as to how exactly the Ford Motor test is going to be applied in the years ahead and how specific a connection courts will demand before exercising personal jurisdiction. I will say, I think one salutary aspect of the case is that for many years, the court, anytime it took a specific jurisdiction case, it would result in one of those horribly fragmented opinions. There's the Asahi case going back to like the 80s. There's a case called McIntyre some years later. But in all of these cases, the votes were like, 3 to 3 to 3 or 4 to 7. Or, I mean, well, that's too much, but that sort of thing. And so it's just like you never could, I mean, it seemed like there were 7 votes, but you just never could figure out what the actual rule of law was. And so for lawyers like us who would have to try to, kind of parse these opinions and figure out, all right, which thing commanded a majority, what do all 9 justices or 5 justices agree on to elicit the governing rule of law, it was exceedingly difficult. Ford Motor, at least, was, a solid majority opinion, and although I'm not, as I say, not enamored of the rule of law, I think it will at least bring some clarity to the world of specific jurisdiction going forward.
So now we're going to have a little intermission between our discussion of the cases from the last term and our discussion of the cases from the upcoming term. Talk about kind of the thing that the Supreme Court has been doing that has gotten the most attention, which is the so-called shadow docket. And so since I took the first cut at the split of the court, I'm going to let you take first cut.
Oh, awesome! I love it, and I think actually, I mean, you guys correct me. Professor Bode is commonly credited, and rightly so, for coining the term. What's kind of interesting about the shadow docket, though, is that it really has been around. I mean, it's not like a new thing. I mean, now everyone's kind of discovered it. But honestly, I mean, it's been around really since the get-go. And the shadow docket, as those of you who follow this sort of thing probably know, really simply refers to cases that the court adjudicates outside its normal decisional process. In other words, you think of a typical Supreme Court case, you think of cert petition, opposition, merits briefing, a public argument for an hour in this, elegant courtroom in Washington, all the public spotlight is on and everything, and you get a big reasoned decision. That's kind of the normal Supreme Court case. The shadow docket is very different because these are cases that come up to the Supreme Court in an emergency posture, often for motions for emergency stay. They're briefed kind of, in 48 hours, just like almost overnight. And then when the court decides it, it doesn't elicit or doesn't release one of its, 40-page thoughtful reasoned opinions. It's often just like a paragraph or two, which can be, difficult to kind of try to read and figure out, well, what does this mean? How does this apply to other cases? I think, from my perspective at least, I think a lot of the criticism of the shadow docket, I think, is misplaced. And I say that because, the question I would put to the critics is to say, well, what would you have the Supreme Court do? I mean, all courts, including the Supreme Court, occasionally are presented with a case that they have to decide in short order. I mean, we've seen in the shadow docket this term, or this past term, there were cases concerning a lot of the pandemic, emergency legislation. So they'd be like, eviction moratoria, restrictions on religious gatherings, types of disputes where, you couldn't adjudicate it on kind of the normal, year to 2 year schedule. They needed to have a decision right away. That was the relief that the petitioners were asking for, and that was the relief that the court had to give or not give. And so I would say, well, what would you expect the court to do? What would you want a court to do other than to do what the Supreme Court is doing, which is to say they do their best, they come out, they decide the case, they issued a reasoned opinion. Maybe it's not as lengthy as they would like, but under the circumstances and the time exigencies that are presented, I think the court is doing an admirable job with it. So at least my view is that I understand why it's getting a lot of attention, because it seems like these really big cases are being decided in this kind of hugger-mugger fashion, but in fact, I think the Supreme Court is acting very responsibly in discharging its duty to, resolve the cases on its docket the best it can.
Yeah, I wish I could say something interesting to disagree with that, but I think the shadow docket is awesome. Other than the name, which is a terrible name. I think the U.S.
I love the name, really.
The U.S. Supreme Court is the only court that's actually specified in the U.S. Constitution. It's really, the Chief Justice is specified. And, it has a supervisory authority and responsibility over the lower courts. And one of the problems, and those of us who litigate both sides of the V, one of the opportunities in the federal court system is a lot of times in these big cases you can pick where you go. You can pick which circuit you want to go to, you can pick which district judge you want to go to. And as long as, especially when we're in a world with nationwide injunctions, which I think we're going to be in, because I don't think there's any real way to do away with nationwide injunctions, the U.S. Supreme Court has a responsibility as sitting at the top of the judicial pyramid to make sure that the lower courts are not doing the wrong thing. And the shadow docket, which is a terrible term, is the best way for them to do it. And I also think that the critiques of the shadow docket are almost entirely outcome determinative and results oriented. Like you heard everyone saying, oh, people are upset. The Supreme Court is striking down, some of the COVID restrictions on the shadow docket. They shouldn't be doing that. They should let the lower courts work it out. But then you have the same commentators when they don't block the Texas abortion law. They're saying, why didn't they stop it? Well, now the shadow docket is a good thing. So I think the bottom line is the U.S. Supreme Court, as the body that's supposed to be supervising all of the courts, has a robust responsibility. And in fact, I think they, if anything, not only use that shadow docket too rarely, they also grant certain too few cases. I think the Supreme Court should take even more robustly its role as necessary to correct the problems that might be happening in lower courts, whether it's on a fast case or a slow case.
I like it. It's like an expanded use of the shadow docket. Do it even more. So, but I totally agree. I mean, I think that a lot of folks who criticize it, I mean, I think you put your finger on it, that they're basically cloaking their substantive disagreements with the outcomes in, procedural garb. That we don't like how they're doing it, when in fact they just don't like the results the court is reaching. So let's talk about this term. I mean, my goodness, it's shaping up to be a pretty good one. Kind of when we were kicking out, what should we talk about? We're like, oh my God, we can fill 6 hours, but we wouldn't subject you all to that. So we wanted to just choose a few cases that we thought were particularly interesting. And so I guess let me just kick that off by talking about a case briefly called American Hospital Association versus Becerra, which is the court's latest dive into the wild world of Chevron. I mean, oh my God, it's like every year you hear about the court has granted cert. This could be the case where they're going to overturn Chevron. This is going to be the year where they rein in the administrative state. When Justice Gorsuch got put on the court, you may recall that there was all this talk in circles, at least kind of the social circles we hang out in, right? Where they basically were like, this is so exciting because when Justice Gorsuch was on the 10th Circuit, he wrote a concurrence where he basically questioned the legitimacy of Chevron. I mean, his point was pretty elegant and straightforward, and many would say correct, where he basically said, look, you go back to Marbury versus Madison, it says in Marbury versus Madison that it's emphatically the province of the judicial department to say what the law is. And so if that's kind of our nation's governing rule of law, well, where do we get off on saying, all right, the agencies get to say what the law is and the courts have to accept it unless it's really wrong? Okay, that just doesn't make sense. Justice Gorsuch said that, and then when he gets on the court, everyone's like, aha, Chevron's days are numbered, right? And it's like, every year we get a case, right, on the docket, they're like, this is it. And it's like Lucy and Charlie Brown on the football, it's like every year they pull it away and Chevron survives. So with that as preface, this year's case is a case called American Hospital, and basically it involves this horrifically boring challenge to Medicare, well, it's Department of Health and Human Services regulations about how they get reimbursement for prescription drugs and that sort of thing. Again, you don't need to know it, you don't want to know it. But that's basically the challenge, and the argument is that the agency overstepped its authority when it interpreted the statute and promulgated its reimbursement regs. And basically, the argument is that yeah, Chevron allows a little bit of interpretation. It doesn't allow what the agency did here, which was just like, carte blanche interpretation. I'm reasonably optimistic, and again, I'm like Charlie Brown, like racing up to that football, but I'm reasonably optimistic that this is a case where the court actually will try to rein in Chevron a bit. I do think that there are 5 votes, maybe not for overturning Chevron, but at least for narrowing its scope and really taking a hard look. I mean, Justice Kagan actually said this in a case the last time Chevron was up, where everyone thought they were going to overrule our deference, which is kind of an offspring of Chevron, where Justice Kagan basically said, look, Chevron is still the law, but before declaring a statute ambiguous, and therefore, kind of allowing the agency to interpret it, courts really need to take a hard look. In other words, don't just like look at a statute, throw up your hand and say, oh yeah, ambiguity. No, you really have to look at it. You really have to focus on it before you allow the agency to perform the interpretive task. So for that reason, I'm reasonably optimistic, MISHA, that this could be a year where they actually do narrow Chevron a little bit. So, I mean, I'll be keeping my eye on this case, and I hope that, once again, I'm not disappointed, but you tell me.
Yeah, look, the way the Supreme Court has treated the Chevron doctrine over the last 10 years is kind of hilarious, which is that as far as I know, there hasn't been a case in quite a while at the U.S. Supreme Court that's actually relied upon Chevron in any way. I think Justice Alito had a pretty humorous dissenting opinion maybe 2 terms ago. It said it was some criminal case, it was some criminal related case that involved agency interpretation, and he said, has Chevron been overruled in some secret decision that I wasn't informed about? So what the Supreme Court has done is basically ignore Chevron. But I think at this point, you can't ignore it forever. You know, lower courts are still using it. It's an important doctrine that if you're going to follow, if you're a lower court and you're following the law, the Chevron two-step, it's like right there. So the Supreme Court really needs to, you know, my theme of what I was saying with the shadow docket is Supreme Court needs to take its responsibility at the top of the food chain at the court seriously and tell the lower courts what it really should be doing with what they should be doing with Chevron, rather than just ignoring it in every case where agency decision comes up. So the next case we're going to discuss is probably the most famous case coming up in this term. Is the Mississippi abortion case, Dobbs. And in this case, Mississippi banned abortion at 15 weeks, which, you know, is, depending on how you look at it, is more generous towards abortion rights than the international average, depending on of how you look at it. And the lower court struck it down because the U.S. Supreme Court had, at least depending on one reading of Supreme Court's precedent, had set a bright line at viability. Mississippi said in its cert petition, hey, Supreme Court, the viability line doesn't make a whole lot of sense. It seems to be even the right to pre-viability abortion seems to be treated as some sort of super right that can't even be overcome by strict scrutiny, which doesn't even apply to like First Amendment and things of that sort. So that doesn't make a whole lot of sense. So, you know, when the case got granted, I thought the case was going to be about whether the viability line makes sense. You know, doesn't make a whole lot of sense. Uphold the 15-week ban and then, you know, let the jurisprudence work its way out. Then something happened in that case that I've never seen in any case, and you know, Tom can tell me if you've seen this, is that both sides took a case that was like an 8 and took it up to like 1,000. So you know, Mississippi in its opening brief says it's like overrule Roe versus Wade, and then it puts the viability question that it put before the court in like a little part at the end. The other side, you know, and the United States in an amicus brief says, yeah, like you have to either strike down the 15-week ban or like overrule Roe versus Wade. So even though the Supreme Court, I think in its grant, was obviously gesturing towards, hey, we're going to uphold this 15-week ban, we're going to do away with the viability line because it doesn't make a whole lot of sense. It's a very, you know, kind of a, you know, it's an important case, but it's not the end all and be all. Both sides have decided to just like push all of their chips in and try to make the court decide an issue which I don't think the court was gunning for when it granted it. And I've definitely seen one side take a case that was an 8 and turn it up to 1,000, but because of a strategic call where it thought the court was going. But I've certainly never seen both sides just purposely ratchet up the stakes really, really high, including U.S. Solicitor General. If ever there was a case for the U.S. Solicitor General to at least call for a middle ground, the U.S. Solicitor General almost always kind of hilariously calls for a middle ground even if there isn't any. Like that's like the SG's move. It's like, you know, it should be either, the question is it 1 or 2? And they're like, it's 1.5. Like it's just like the way they roll. And certainly they were gonna defend the lower court judgment and say the 15-week ban was struck down. But you would think that based on how the SG normally operates, they would have been like, well, there's a very obvious middle ground here. Which is to uphold the 15-week ban, but don't get rid of Roe versus Wade. And they said, I think they have a line in there that says there is no middle ground here, which is just like, but quote that against the SG in every case from now on. So I've never seen a case where both sides and the United States took a case that was important and made it like the most important one in a way that didn't seem necessary for either side to do.
Yeah, let's go big or go home.
Yes.
I mean, it'll be interesting to look. I mean, who knows? I guess I'll go out on a limb and say I predict the outcome will not be unanimous. But I mean, to me, at least, the more interesting question, right? The relevant question is just whether the quote-unquote conservative justices all stay together, or whether or not the liberal side is able to peel off, you know, say Roberts and Kavanaugh, and kind of, you know, even if they scale back Roe, whether they kind of still preserve the core of Roe and Casey, or whether they just, you know, junk the whole framework. I don't know. I mean, you know, this is the ultimate test. You hear a lot to talk about how the chief and certainly Justice Kavanaugh to some extent are kind of institutionalists in the sense that they're very, you know, they respect stare decisis, they're concerned about the institutional role of the court, the perceived legitimacy of the Supreme Court, and for that reason they might be a little more cautious than, say, you know, Justice Alito or Justice Thomas, who are ready to, you know, make the world anew. God bless them. But, you know, we'll see what happens. You know, I mean, all eyes are going to be on the court in December when this thing gets argued.
Yeah, I mean, I don't think the chief and Kavanaugh wanted to be at 1,000. I think, you know, it would seem to me obvious, at least from the chief, that the way that he would want to resolve this is to say the 15-week ban is fine, and that's all we're deciding for today. Now, we'll see if the way that both sides and the United States have briefed this is just not going to leave them that practical option, and they're going to have to do an all or nothing bite. But generally, litigants don't tell the Supreme Court what they should do. The Supreme Court tells litigants. So I think they're going to find their way to the way they want to handle this case.
All right, well, let's talk about something less controversial than abortion. So gun control is also on the docket. So the Supreme Court granted cert in this case, the New York State Rifle and Pistol Association against New York. And this is an interesting case. It's basically, it's kind of one of the many follow-on cases to Heller, which, you know, is this group knows, years ago involved the question whether the Second Amendment extends protection to keeping a firearm in one's house. And this question basically, this case presents the question of how far does that right extend? Namely, does it extend to carrying, you know, a firearm outside one's house? And so the statute or the law that's being challenged in this case is New York's concealed carry requirement, which basically, as I understand it, says that you can get a permit to have concealed carry firearm if you can show quote-unquote proper cause. And so this has been challenged as violating the Second Amendment. And here, I guess maybe unlike the Dobbs case, the Supreme Court did narrow the question. This is one where the petitioners, I think, wanted a more robust holding about the scope of Heller, the scope of the Second Amendment, and the Supreme Court rephrased the question presented, which sometimes they do, not always, but they rephrased the question presented and said, this is the question we're going to decide. And it's, as I stated, it's whether you know, New York's the proper cause violates the Second Amendment. So here, I think what's very interesting to me, at least, is the fact that they granted, because a term or so ago, the Supreme Court had another case, actually also brought by the same New York gun group, on its docket. That case mooted out, and at the time it mooted out, the court had something like close to a dozen pending cert petitions, and you know, a lot of folks, including some of the justices, were like, all right, no big deal, let's just take another from the stack. And so we were all trying to kind of figure out, all right, which one are they going to take? Well, surprise, surprise, they didn't take any of them. They denied all of them, which is frankly a bit of a shocker because they clearly wanted to kind of decide this type of issue, and they had 10 reasonably strong options, and they issued all of them. So when they granted here, people were obviously very interested. I mean, it seems to me, again, probably not going out on a limb, that they probably wouldn't have granted if they intend to simply say, New York's doing everything great here. My guess is that they will extend Heller. And look, I think it's helpful. I mean, the Second Amendment, I think Justice Thomas is right in that in many ways it's been kind of the forgotten amendment. It rarely gets litigated. You rarely get Supreme Court decisions on it. There are some who kind of just seem to read the Constitution and skip over from the first to the third. The Third Amendment is what the quartering in the houses, right? Soldiers in the houses, and more people know that than seemingly know the second sometimes. So I think it's great that they're getting into this area of law and maybe bringing some clarity to it. And as I said, it seems to me unlikely that they would kind of rein in the scope of Heller and the scope of Second Amendment protection, given that they've waited and waited and waited finally to grant in this case.
Yeah, I mean, I think Tom's prediction on this one is right on. I mean, the New York law basically says that if you're going to exercise a constitutional right, you've got to show a really good reason. Basically, like, gangs are coming after me, I need the guns. Like, I mean, think about like if they treated any other right that way. It's like you only get to like have the right to free speech if like you really an issue is coming at you that if you don't speak, it's going to come out the other way.
You have to like show it.
Exactly, before you can speak. So I think it's a bit. I think if New York is smart at oral argument, they're going to be trying to limit the damage. Because I would be very surprised if something like this law withstood. And I think this one is probable that it will be the more traditional 6-3 split. So I do want to leave a lot of time for questions. So I'm just going to say like 2 sentences about the last case, which is the Carson case. Basically, the state of Maine says you can't use the state's funding voucher program to go to religious schools. A decade or two ago, the question was whether it was permissible under the Establishment Clause for states to give these vouchers and other funding for kids to attend religious schools, and there were people from the ACLU arguing that was unconstitutional. The world has really changed since then. There's no dispute that that's constitutional. And now the question is it constitutionally mandated that if you're going to have a voucher program, it has to go to those who are sending them to religious schools? I think it's pretty clear, at least in my judgment, that the Supreme Court is going to finally complete that path and say that you can't have a voucher program that says you can spend those vouchers only on secular schools, not on religious schools. And then that will be, not much of a whiplash from where the Supreme Court's jurisprudence is now. I think that's a very short step, maybe even no step at all, from where the court's general free exercise clause jurisprudence is. But it is quite a whiplash if one looks at the law in a longer frame. Where 30 years ago, I think the conventional wisdom at the core was that perhaps it wouldn't even be constitutional to give that funds.
Yeah, no, I totally agree with that. I mean, this is a court that's exceedingly strong on religious freedom issues. I mean, I actually when I mean literally this room, I think back to when I was a law student here, I had Professor McConnell who taught religious liberty in this room, and so much of I guess what he hoped for and aspired to is now becoming the law of the land. It's impressive. I mean, you look at the court's decisions both on their plenary docket and also on MISHA's shadow docket that you love. They are just coming out so strongly in favor of free exercise and religious liberty. I mean, I'm honestly hard pressed to kind of think of a case where they've rejected a claim to free exercise or rejected a claim that would kind of increase state control over religious exercise. So it's I mean that is definitely a case that it doesn't surprise me that the Supreme Court took it, and it will not surprise me when they rule in favor of allowing the money to be spent.
I think it might be even more than 6 votes.
So yes,
Even more than 6 votes in this one.
that would not surprise me either. So. Okay, let's see, just to keep everything on track, I guess would love to entertain thoughts, comments, questions, anything from the group.
You mentioned that in the New York State Rifle Association case, New York might, in oral arguments, try to limit the damage. Could you elaborate on how it might do that?
Yeah, I mean, so obviously, we think this law is going down in flames, but there's a methodological fight in the case about whether you apply intermediate scrutiny or strict scrutiny to laws that burden the right to bear arms, and in what circumstances those happen. And if I was arguing for New York, I would try to get the court not to decide those questions and try to keep them focused on the rewritten question presented.
Yeah, and I would imagine some of the justices might kind of try to be angling their colleagues. So if you'll indulge me in a personal anecdote, I had a case that I argued a few terms ago. It was one of the ones I mentioned earlier in my talk, the Daimler versus Bauman case, where it was personal jurisdiction, and it was clear, kind of the argument that, kind of I was going to win. So then, toward the end of the argument, Justice Sotomayor kind of leaned forward, and she wasn't entirely on our side, but she kind of leaned forward and she said, it's the greatest question I think I've probably ever gotten in my life as a lawyer. She said, Mr. DUPREE, do you care how you win? And I thought, yes, and the answer actually was yes, because to your question, I mean, it was a situation where the court kind of had two outcomes. It kind of had a potentially broader outcome or a narrower outcome. And I think that kind of once the temperature in the room got to be, okay, the petitioner is going to win, immediately both the advocates and, sometimes I think the justices kind of start shifting into, damage control mode. In other words, to basically say, okay, our view is not going to carry the day, but maybe we can persuade our colleagues not to kind of, go whole hog. I mean, fortunately in Daimler they did go whole hog, which is great. But nonetheless, that's a situation where I think a lot of times both the justices as well as the advocates think strategically in terms of kind of how to influence the court.
Yeah.
So, more questions?
Yeah, I was wondering if maybe I'm missing something, but my understanding is that the core holding, at least with Casey, does concern viability. And then the undue burden test only kicks in once you're talking about viability. So I'm just wondering, you mentioned that you both thought there was a middle ground that the justices might stake out, but given that 15 weeks is mostly regarded as before viability, I'm wondering how you would see that play out.
Well, I'm obviously, to the extent one reads Casey that way, you'd have to overrule. You don't have to the extent one reads Casey that way, you'd have to rule that aspect of Casey. But what I mean when they amped up to 11, they weren't, or 1,000, they weren't saying you got to either overrule Casey. They're saying either you have to uphold, either you have to strike down Mississippi's ban, or you have to say there is no more right to abortion. And that's the choice they were putting to the court. Given that most of the countries in the world, liberal democracies, don't have abortion bans only under 12 weeks, it is very easy to envision a world where Mississippi's 15-week ban is upheld, but for example, one with 6 weeks from Texas was not. I'm not going to say which side I think the world should be on. That's not my point here. My point is, it is simply not true that there's no way you could have a jurisprudence that either Mississippi's law goes down or there's no right to abortion. That's just not true. And it was a strategic choice that both sides made to put the court to that all or nothing choice. And, the court pretty much made up Roe and Casey when it did, and if it wants to continue to have an abortion jurisprudence, there's no reason that it has to be wedded to what it made up at that time. They could make up something else.
So in the past year, there's been a lot of perhaps unfortunate rhetoric about reforming or doing other things to the Supreme Court. Do you see that having any effect on how the justices rule, or is it a totally irrelevant thing?
Yeah, that's a great question. I mean, part of me says that the justices honestly just kind of tune it out and do their jobs. But other parts of me think that, look, the justices are like everyone. They read the newspapers, they see the criticism, and we know, we have it on fairly good authority that some justices, I'm again thinking of the chief, are exquisitely attuned to kind of, how the court is perceived in society. I mean, Justice O'Connor was kind of well known for this also, and that, again, not to say that they're these political animals that follow, the day-to-day poll or anything like that. I'm not suggesting that, but I think they're conscious in a larger sense of how the court is perceived. Because, I mean, look, it would be true that if, a majority of the Americans started just losing faith in the court as a legitimate, nonpartisan, independent actor, would be in trouble as a society, because query, why would people, obey the court's dictates if they just felt it was completely illegitimate? So I guess, where I would come down is I would say, I think it probably does affect some justices at the margins. I think it's much harder to say, well, how does that translate into, for instance, what cases do they grant, how do they come out, and things like that. That's much harder, because it's hard for me to see a justice saying, this is the correct way I think the Constitution should be interpreted, but it's going to be unpopular, so I'm not going to, I don't think that they would go that far.
So I'm interested in y'all's thoughts on the format of oral argument. Do you guys have a preference for the sequential seniority to, I guess, the most junior justice versus the free-for-all style?
Did you do any arguments under the style? I didn't do any arguments.
No. So I guess my sense is that I think the free-for-all works better, to be honest. I think one wonderful aspect, by the way, of the sequential is that they brought Justice Thomas out, and now that they've gone to the free-for-all, he can't ask enough questions, which is wonderful. But I think by and large, I think the free-for-all tends to work better. I think it's more natural. I think the justices have a better way of eliciting information than when you go in the sequential order. I'm a little skeptical that this new hybrid thing that they're trying out is going to work, where they kind of have the free-for-all and then at the end they say anyone have questions and they go sequentially. I mean, so far, obviously the still early returns, but not all justices even avail themselves of the follow-on round. There might be a few questions here or there. So I'm not sure that piece of it is going to stick, but I think free-for-all is better. I think the sequential was interesting. It was a fascinating academic experiment. As I said, it brought Justice Thomas out of the woodwork, so that's wonderful. But I think it's good to be back to the normal way of things.
Yeah, well, the sequential thing is no good, but I do think that there is one problem with the free-for-all that the justices need to talk among themselves to fix, is that each justice needs to think about their role in the free-for-all. And I think I had an oral argument a couple years ago, and I think I had a 20-minute block. Justice Breyer says to me, I have a question for you, it's going to take exactly 30 seconds. His question took 3 minutes and 14 seconds. And it was a good question because it had embedded within it, several parts that if I had been able to respond to it, I think I would have been able to cover everything that I really needed to cover. I got 22 seconds into my answer and Justice Kagan interrupted me and asked me something else entirely. So it's really not, that doesn't serve anything. And so in a sequential format, that would not have happened. Right? Justice Breyer would have run out of us the whole time just articulating that question, and then Justice Kagan wouldn't have been able to knock me off my answer because she knew I was going to kind of explain to Justice Breyer why he had perfectly set, it was a perfect setup question. It was like each part of his question was another problem with the other side's case. And so, I think the justices, to keep this format, to keep the best parts of the sequential format, those who are going to ask questions like Justice Breyer did at that time should really try to ask the question in 30 seconds. And if justice goes longer, Justice Kagan should allow the litigant, the advocate to answer it, at least in a fair amount of time compared to the length of the question. And if the justice would do that, then I think the free-for-all would be in all ways better than the sequential.
I found what you guys do exceedingly interesting. I'm new to this, I don't really understand how this kind of work would follow a place like Gibson. So I was wondering if you could just speak to how you make good money, how this kind of work.
That's an awesome question. Oh my God, I wish I had more than a minute to answer it. I mean, boy, I guess, let me say several things. First is we do make money, so we are a for-profit entity. But I will say that the nature of Supreme Court practice has changed fairly dramatically, even in the time that I've been in practice. In other words, it has now become a situation where many well-known Supreme Court practitioners, some at well-known firms, others at sole practitioners or with smaller boutique-type firms. I don't want to say they do the work for free, but they do the work for free. I mean, it's the market incentives or the market structure has changed dramatically because I think people recognize that kind of, the prestige and the excitement and importance of a Supreme Court argument is such that, since so many people will do it for free, it's hard to kind of be competitive. So it is a challenge. I mean, I guess just speaking at Gibson Dunn, I mean, knock on wood, we've so far been kind of able to navigate that. As I said, the firm as a whole, our appellate Supreme Court practice in particular is profitable and we do, charge money for our work. But it's become hugely more competitive and difficult. And so, again, without getting too granular, you can address it by, doing, flat fees, alternative fee arrangements, ways that you can kind of, try to limit the financial impact to the client and still get the work. But again, it makes it very difficult, right? If kind of I'm saying we'll do X and, someone down the street who's, of equal value, not that there are such people, but if there were, they'll do it for 0 or half X. It's
people who would have gotten the middle result in the
exactly. They would have said to Sotomayor, oh, we don't care, just rule, right? That's what you'd be paying for. Now, but it's a very, very competitive world. I mean, the Supreme Court bar is exceedingly difficult to, make a living in, no question about it.
So Tom answered the question from kind of how do partners at really profitable firms like Gibson Dunn do it. It's hard for those of us who are kind of younger partners trying to build a book of business and be profitable. That's not where you make your money. And frankly, I don't really target Supreme Court merits work. I don't. I'll do amicus stuff and some of the cases that we've talked about today. I wrote paid amicus briefs. Those aren't hugely profitable, but they're not. You don't take a big loss. But when you're talking about in your shoes, as folks who are really good law school, hopefully doing well in your classes, the way you can do this kind of work is go to places that do that kind of work. And then you don't have to worry about all the stuff that we're saying here about how hard it is to do it and how it's really frustrating that in order to do a U.S. Supreme Court case, I basically have to offer to pay the litigant to let me do it for them and things of that sort. Like for you, just take a look at either law firms if you want to make more money or public interest organizations if you're not as concerned about money but you will get paid, who are doing Supreme Court work, and even more importantly, who are doing the kind of Supreme Court work you want to do. If you go there, you'll get to do Supreme Court work as a younger lawyer. No one's going to be expecting you to bring in paid U.S. Supreme Court cases 3 years out of Chicago.
I think we have time for about one more question.
Yeah.
Do you think this will be Justice Breyer's final term?
No. Not a lot of confidence.
Yeah, I'm the same way. I probably would say no, but I don't have a lot of confidence. I mean, it's an incredibly difficult decision. I mean, if you're Justice Breyer's shoes, I mean, we all understand kind of the incentives and the thought process that goes into it. I mean, I do think one kind of I guess disappointing aspect of just our political world these days, and this doesn't go just to Justice Breyer, is that you do see justices, kind of, and federal judges, timing their retirements with the political cycle. Again, I totally understand why it happens. I'm not saying that any particular decision was wrong or shouldn't have been made or anything like that, but I think it's a little corrosive because my concern is that Americans see that and they think, okay, they all have a big R or a big D on their judicial robe, and that's not how it works and that's not how it should work. But I worry that there's that perception that by linking their tenure to the political cycle, that they become partisan actors in a way that the founders certainly didn't envision.
Yeah, and I think that a lot of the speculation about should people retire, urging people to retire, getting mad at people for retiring, has happened to my former boss. I think I actually understand why that happens because these cases that the Supreme Court decides are so high stakes. But I think it forgets that these are human beings. A lot of people were really mad at Justice Kennedy for retiring because President Trump was president, they didn't like him or whatever. But Justice Kennedy, he wanted to be a grandfather. He wanted to, I think people, or even more disappointing is like a lot of people's reactions when Justice Ginsburg passed away, immediately turned to the political thing. I mean, she was a great woman. The first thing is that when people talk about that, and I think it's important, even while we recognize the stakes are so high, to remember the humanity of the justices. Because if you discount that, yeah, sure, they're just people like we're people. But if you're really looking at people in that way, that transactional way, it's not a respectful way to deal with people, including people who are really powerful.
And that will be the conclusion of our annual Supreme Court Roundup. Please join me in thanking Mr.